Okay, are we ready to get started? Okay, welcome to everyone who's joining us. My name is Rick Bales. I teach at Ohio Northern University, and I guess we are all here to celebrate the launch of our new book on the Federal Arbitration Act. I got the idea for the book probably 5 or 6 years ago when I realized that the hundredth anniversary of the book was coming up. And that seemed like a good opportunity to kind of look back on what the FAA was intended for and what it has become. It, it will come as a surprise to absolutely no one on this Zoom that the FAA has morphed into something far beyond what its congressional drafters had ever envisioned. When it was originally drafted, and for really the first 60 years of the statute's existence, it applied only to commercial contract disputes because the terms of the FAA itself seem to foreclose labor or employment arbitration. And the Supreme Court for many years interpreted the statute as excluding arbitration of statutory claims, saying that those should be reserved only for courts. But starting in the roughly the 1980s, the Supreme Court reversed course, and over really the next 40 years, significantly expanded the scope of the Federal Arbitration Act to include employment disputes, consumer disputes, statutory claims. Um, just about everything these days is has become arbitrable, and often the Supreme Court um, took some liberties with the language of the statute to further what many perceive to be its policy goal of encouraging arbitration, perhaps privatizing justice, uh, and removing many cases from what would have been the court system into a private dispute resolution system of arbitration. Now, whether we could certainly debate whether that's good or bad. The book certainly does that, and that's kind of the whole point of the book is let's look at that change over a long period of time, and talk about how whether this is a good thing, whether it's not, whether this the 100th anniversary should be an opportunity uh, to to reflect and to perhaps think about change. Um, when I started thinking about the book project originally, I well, I great I just thought, this what a wonderful opportunity to work collaboratively with some great people. And my first thought for a co-author went to Jill Gross. Um, I worked with Jill on a couple of projects before. We served on a couple of symposium panels and before, and I knew of her great work, and I knew that she was a wonderful person and would be really great to work with. But another huge advantage of working with Jill is that we have very different kind of subject area expertises on arbitration. Her focus has been mostly securities. Mine has been labor and employment, and so that I guess our experience and our expertise complemented each other, which gave us, I think, the ability to reach out to a much more diverse group of potential chapter authors. And then that we put our heads together, came up with some basic chapter topic ideas, made a list of all our favorite friends in the Arbitral Academy, and reached out. And you know what we have now is a product of that. Uh, this has been a one of the best experiences of my professional career. The opportunity to work with Jill, the opportunity to work with all of the chapter authors on a collective project that I'm very proud of and very proud to have worked with so many smart, talented, gifted people. Uh, I want to thank you all for making this possible. The idea behind the book was to to invite people from different perspectives who have, very different areas of expertise, and uh, and not to preach in one voice necessarily, but to encourage authors to to write in their areas of expertise and to make proposals that might sometimes be conflicting. Uh, the idea is that to bring together some very smart, talented people and to look at the statute from all different perspectives. And I think that from that, the sum of the parts becomes much stronger than any one piece of the puzzle by itself. So with that, I'll turn it over to Jill to talk about to say just a few words about the FAA's history, if you want to, and then I think we turn it over to Steve.
Great. So thank you so much, Rick. I cannot thank you enough for inviting me to join you on this project. It was a wonderful idea, and it turned out to be an amazing experience. I think our partnership was really, as I think you said, perfect in terms of our working styles. Ever since Rick approached me with the idea for this book project, I had been really excited about the notion. First, of course, a birthday celebration. Who doesn't like a birthday party with the FAA turning 100 years old in 2025? But also coming up with a roadmap for reform, which to me, all wrapped up in one volume, to have this many different suggestions for reform, ranging from updating some of the language into plain English and gender neutrality, all the way to excluding types of claims from the scope of the statute, like consumer or securities, or abolishing the statute entirely. All of these ideas, all wrapped up in one volume, was a really exciting project for me. So it's been really a great experience. And even if only one of our reform recommendations from our roadmap is adopted by Congress or the Supreme Court in our lifetimes, we will have made a difference in the lives of the many people in this country who are impacted by what I consider the overpowering Federal Arbitration Act. The book proceeds in 8 parts. We have a representative from one chapter in each of the 8 parts. Each part has about 3 to 4 chapters, depending on the part. And the speakers you'll hear from today will just spend a few minutes describing the thesis of their chapter and how it fits into the 8 parts. And then after we hear from each of the speakers, Rick and I will wrap up and field any questions that any participants may have. You can put them in the chat and we'll be happy to answer them at the end. It's so wonderful to see so many of our chapter contributors either on the screen that you all can see or in the list of participants. I can see many more chapter authors in that list. So we're thrilled to have all of us, as many of us together as we could possibly gather. Rick and I co-authored the introduction, which just shapes the structure of the book, the kinds of chapters and the kinds of reform suggestions that the rest of the book has. That's part of part 1 of the book, which talks about the history of the Federal Arbitration Act, which for many of you is well known, and some of the politics behind the passage of the act and some of the movements for reform that have preceded this book. I learned quite a lot about the politics behind the FAA, which I'm so thankful for the chapter authors in this part. That being said, I'm going to turn it over to Stephen Ware, who wrote a chapter in part 2 called Enforcing Arbitration Agreements, and he can describe his chapter to the rest of us. So thanks, Stephen.
Thank you. Thank you, Jill, and big thanks to Rick and Jill for organizing this whole project so well. Truly an example of the whole being greater than the sum of the parts. And most of the credit for that goes to our two leaders, Rick and Jill. So big thanks to them both. And this book, as already alluded to, so many parts to it from so many different authors that it's really a terrific resource for those of us thinking about arbitration law going forward. Just in the last couple of days, I drew on Hira Aragaki's draft chapter in some other research I was doing. So I hope everyone here will use it as a research tool in the future. I think it's going to be great for that. This section of the book, part two of the book that Jill asked me to speak to, has several contributions on enforcing arbitration agreements. And this, of course, has been among the most controversial aspects of the law, such that adhesion contracts involving consumers, employees, securities arbitration, and so forth. Lots and lots of people advocating change to the law there, and we see some of that in part two of this book, as well as the later part on consumer and employment arbitration. But my particular contribution sort of goes in a different direction on a different type of parties, which is the more sophisticated parties. And here I would like to expand the Federal Arbitration Act's enforcement because the Federal Arbitration Act only requires courts to enforce agreements to arbitrate claims that arise out of the contract containing the arbitration clause. I call this the arising out of requirement. Only enforce agreements to arbitrate when the claim, the dispute itself arises out of the contract containing the arbitration clause. And some terrific scholars, particularly David Horton, have drawn attention to courts under enforcing this limitation in the Federal Arbitration Act. In other words, courts have enforced agreements to arbitrate claims that do not arise out of the contract containing the arbitration clause. So pat on the back to those scholars for pointing out courts straying from the statute in this regard. And it got me thinking, well, what if courts hewed closer to the statute and only interpreted the FAA to enforce agreements arising out of the contract containing the arbitration clause? I think that would inhibit some really creative, potentially productive arbitration agreements among sophisticated parties. And since time is short, I'll just give a couple quick examples so you get a feel for what I'm talking about here, which is imagine Apple and Samsung, two big tech companies, formed an agreement to arbitrate any patent infringement disputes that might arise between these two big companies over the next 5 years. They hope there will never be any patent infringement suit or dispute between them, I presume, but they're anticipating, hey, we step on each other's toes a lot in the tech world. We have disputes pretty regularly. We would like the expertise of arbitration. We would like to bind ourselves now to arbitrate rather than litigate those possible future disputes. That would not be an enforceable agreement under the current FAA, because a patent infringement dispute would not arise out of this standalone arbitration agreement hypothesized between these companies. And I think it's an agreement that should be enforced. Another example would be the Walmart family, the Waltons. Imagine if all the members of that family agreed to arbitrate any dispute arising out of any will or trust their family documents, family financial situation for the next 10 years. That also would not be an enforceable agreement under the FAA as it is now, and I think it should be. One last example, and then I'll yield the floor, which is torts, automobile accidents. Think of companies that have a lot of trucks delivering packages UPS and FedEx, if those two companies made an agreement to arbitrate any tort claims arising out of car accidents for the next 5 years, FAA would not require enforcement of that agreement too. So basic case I'm making here is that allowing these kind of parties to make and enforce these kind of agreements might lead to some really interesting innovations in dispute resolution and arbitration, but also might divert from the public court system these cases of parties that can afford their own private adjudication in arbitration and leave the public resources for other disputes where the parties don't have those kind of resources. So that's the argument I make, and I'm very interested to hear what everyone else has to say.
Ron, you're up.
Well, thank you, Jill, and thank you, Jill and Rick, for the wonderful job you've done in pulling this book together. It's been wonderful working with you. So thank you, everybody, for joining us today. My chapter is in part 3 of the book and is entitled Pressing the Restart Button, Amending Federal Arbitration Act Section 2 so that state law, rather than the Federal Arbitration Act, regulates adhesion arbitration. And by adhesion arbitration, I'm referring to what is often called mandatory arbitration clauses that are contained in contracts of adhesion, take it or leave it contracts. So the proliferation of adhesion arbitration has been quite controversial over the last few decades, since the shift in focus that Rick described over the last few decades has taken place with regard to the scope of the Federal Arbitration Act. Today, millions of Americans are parties to arbitration agreements and often don't know it because they had to sign an adhesion contract to get a job, to buy a product, or get a service, and as a result, to have, excuse me, any dispute that arose in connection with those contracts to be subject to resolution only by binding arbitration. That it can often include class waivers of the right to proceed on a class action basis as well. So how did this come to be when you have a statute enacted 100 years ago that focused on merchant-to-merchant disputes? The answer is a series of Supreme Court decisions that Rick alluded to over the last 40 years that have resulted in not just a pro-arbitration policy, as we often see, but effectively a pro-adhesion arbitration policy by as a result of decisions that have allowed large businesses to be able to include and enforce adhesive arbitration clauses as part of employment, consumer, small business contracts where there's a great disparity in bargaining power. So these holdings have involved a variety of conclusions, ranging from the Federal Arbitration Act preempts state law regulating the substance of arbitration and is applicable in state court. Adhesive class waivers are enforceable. Adhesive arbitration agreements can be included in employment contracts in almost every sector involving interstate commerce, except the transportation sector. Unlike class action litigation, you can avoid being sued in a class action unless you contractually agree to do it, which relatively few people are going to be inclined to do. State law, even generally applicable state law, canons of interpretation, for example, can be preempted if it's inconsistent with this pro-arbitration policy, including rules that provide for construing contracts against the drafter, the large corporation that drafts the adhesion contract, especially in the class action area. So the question then becomes, how can this be addressed? It's unlike the court has given no hint that it is likely to reconsider its pro-arbitration policy decisions anytime soon. As a result, a legislative solution is going to be necessary. And there have been a number of very fine legislative solutions that have been suggested. My focus in the proposal in my chapter is on addressing the economic issue, the potential abuse of economic power that comes from the ability to impose adhesive arbitration on others. And the proposal I'm making is that Congress should amend the Federal Arbitration Act to remove from its scope adhesive arbitration agreements. The effect of doing so would be to eliminate the impact of these series of decisions that I alluded to with regard to making adhesive arbitration agreements, adhesive class waivers, and the like enforceable, excuse me, against employees, consumers, small businesses, and so on. Because all these decisions interpret the Federal Arbitration Act. The Federal Arbitration Act no longer governs adhesive contracts, adhesive arbitration agreements. Those decisions have no impact anymore. So what's going to happen if you remove the adhesive arbitration agreements from the Federal Arbitration Act? There's a regulatory vacuum that's created. What's going to fill the vacuum? The law of the several states. States would have the opportunity as a result to fill that vacuum by making their own policy choices with regard to how to best address the question of either whether to allow adhesive arbitration at all, and if so, under what circumstances. So states could simply ban adhesive arbitration if they believe that to be the best policy choice. They could decide that a generally applicable contract law dealing with adhesive contracts should apply to adhesive arbitration agreements as well. Or courts or states could decide that there can be a place to provide fair, efficient, and effective access to justice with appropriately regulated adhesive arbitration, and to craft a legislative scheme that would provide for appropriate reforms with regard to making adhesive arbitration possible, but with, whether it's in terms of discovery, opt-out rights, expanded judicial review for public law claims, other sorts of reforms that would be potentially available under, if the states are allowed to regulate, that currently can't happen under the existing federal legislative scheme. So this way, states could serve their role, to go back to Justice Brandeis, of being regulatory laboratories, develop best practices for how to address adhesive arbitration, and allow the opportunity to see if the potential promise of arbitration to provide for cost-effective, fair, efficient dispute resolution can indeed be realized in the adhesive arbitration setting, by allowing us to press that restart button, rethink about, think again about, and start over with regard to whether or not adhesive arbitration should be permitted, and if so, let the states take a look at that by removing that Supreme Court jurisprudence that allows for the current problematic adhesive arbitration regulatory structure. So that's, in a nutshell, the proposal that I put on the table. It fits within the this role of state law section that the article is nestled in, along with the other chapters on federal preemption and the intersection of state and federal law. So thank you so much.
Amy, we cannot hear you. Maybe it's me. Can anyone else hear you? No.
Now can you hear me?
Yes.
The rookie move for the person who's talking about technology. That's sort of So I just want to say thank you so much to Jill and to Rick, and congratulations on what you've achieved here. This is really important work and really impressive the way you've orchestrated everything. So thank you. So I'm talking about sort of procedures, jurisdiction, petitions to compel, and subpoenas in particular. My chapter is really focused on the way that technology has transformed arbitration with the prevalence of online arbitration. We see a lot of use of virtual hearings, especially, of course, after the COVID shutdown. Many arbitrators and parties became quite enamored with online arbitration, or what I call OARB. But there is a wrinkle here when it comes to Section 7 of the Federal Arbitration Act. That section states that third-party subpoenas are only allowed when the party, the witness, is going to attend before them, quote unquote, meaning in person or before the arbitrators. Now, managed care associates came out of the 11th Circuit and really threw a monkey wrench into it by holding that, well, if it's an online virtual hearing, then Section 7 can't be used. There's no power to order the documents or the witness to participate under Section 7 because before them only refers to physically before them, really taking an originalist view. Other circuits have looked at it more from a functional analysis and have said, well, you know what, that's fine. Before them can include virtual attendance. So it's created a circuit split that actually matters. It matters when you talk to counsel, it matters when you talk to arbitrators, because often you do need that third-party evidence, and it becomes really important to have the power to use Section 7. At the same time, we don't want to discourage the use of online arbitration, given that it can save the parties a lot of time and money, and really has become, a lot of people have become quite comfortable with it. Of course, it's not perfect for all cases or all people by any means, but where it is appropriate and where both parties would like to have an online hearing, it seems that should be allowed, and Section 7 should allow for use, even in a virtual hearing. So what I propose is that the language of the Federal Arbitration Act be amended to make clear that attendance before them includes both in-person and virtual attendance. So pretty simple, not very complicated, but currently there is quite a split in authority between the federal courts and amongst state courts, so it does matter. Thank you.
I think, Rick, you're up next to talk about your chapter in Part 5.
Short. My part here will be short as well. The OWBPA was originally drafted to deal with the Americans with, I'm sorry, the Age Discrimination in Employment Act. Sorry, I just went completely blank for a second there. But the basic idea is that, look, before employers coerce employees to sign away their employment discrimination rights under the ADEA, perhaps to settle an existing claim, it's only fair to expect that employees should know what they're signing. And the OWBPA is the Older Workers Benefits Protection Act, and which was passed by Congress as kind of an adjunct to the Age Discrimination and Employment Act to ensure that workers, before they sign away their rights, they know what they're signing. And so it has some really kind of common sense requirements. An employee has to be given advance notice before he or she is given a contract and told to sign it. They have a certain a period of time in which to consider it. They have to be told, for example, that they have an opportunity to have it reviewed by a lawyer. The language has to be written in plain English, not a whole bunch of lawyer created legalese gobbledygook, full of Latinisms. Really pretty much that simple. And given what Ron spoke about just a few minutes ago, and about how the FAA is being used to enforce adhesive contracts against parties with very little bargaining power, I think it's kind of the same thing, right? The consumers and employees against whom many adhesive arbitration agreements are being enforced are in much the same position as the older workers who were being given age discrimination settlement agreements and told, you have 5 minutes to sign, here's the piece of paper, sign it or the offer's off the table. And so although I agree with Ron that it would be better perhaps to amend the FAA to exempt adhesive contracts, especially employment and consumer contracts. A second best alternative might be to adopt the procedures of the OWBPA and to at least make sure that employees and consumers and anyone signing an arbitration agreement knows what it is that they're signing, or we enforce it against them. That's it.
Great. So I think that brings us to John, who will be talking about his chapter in part 6.
Yes, thank you. And I will probably take the 5 minutes. I and my co-author, Mark Travis of Tennessee, are both arbitrators, not academics. And I've been a trial lawyer for the first 30 so years of my practice. The last 10 to 15, I've been an arbitrator almost exclusively in complex commercial cases, but I also do some FINRA cases, some consumer, and Mark is an employment arbitrator primarily. So we do span sort of the gamut. And our chapter, which is on reforming the judicial review to permit bargain for and fast track review, the most important part to me concerns the judicial review and the problem that was created for parties by the Hall Street opinion in 2008, where the Supreme Court held that under the FAA, you cannot enforce party agreements for full judicial review or any kind of judicial review beyond the listed elements in the FAA. And that turned out to be a dispositive question in that case. Why did the court do that? It said that the issue, as it framed it, was whether the grounds for vacatur and modification are in the FAA, sections 10 and 11, are exclusive. And it said, looking at the statute, it had an originalist interpretation. Section 9 says you must confirm if the grounds in section 10 or 11 don't apply, in which case you would vacate. And I think it's one of many examples of the problems of what I'd call unreasoned originalism, not looking at the context. The court also added a second reason that's totally contrary to its normal thinking, which is that if we allow judicial review, that will throw arbitrations back into cumbersome court processes, and that's not consistent with the nature of arbitration. But it's what the parties choose, and everywhere else, except also in class cases, the court has said if the parties choose a procedure, even if it's less efficient, we have to follow it. And just to give you a flavor, we make 5 arguments on why the court's wrong, and then have language that Congress could use to amend to authorize full parties to agree on full judicial review at the end, which I won't discuss. But the most important reason, I think, is that the party participation, party choice, party design is the key part of arbitration. It's why it's so important. And the court has stressed this in case after case after case, including, very prominent cases like the Concepcion case, Stolt-Nielsen, not one of my favorites, but the principle is in there, the Volt case, the first options case. And it's stressed at the same time that if the parties agree on a procedure, even if it's inefficient, it's our job to carry out their wishes. That's what arbitration is about. And I think for people who want to protect arbitration and the rule of law where parties make choices, we enforce them, it's really important that their choice of judicial review be honored. But the court, of course, said, Congress meant something different. What it ignored is that there are hundreds of years in which, including before the FAA, American courts always would intervene and review if the parties agreed that's what they wanted. And sometimes they would even do it if they thought the arbitrators gave legal reasons they themselves must want judicial review. But it was true in 1925 that if parties agreed on judicial review, courts would enforce that agreement and fully review awards. In 1953, in the Wilco case, the court actually relied on a common law ground that's not in the FAA, what was manifest error. It called it manifest disregard. So again, is building up the law of party choice and awards being reviewed to sort of deal with the problem of parties who say, you can't appeal an arbitration award. Obviously, if parties can agree to full judicial review, that's the most prominent way to get a right to appeal. And even in Hall Street, the court inconsistently admitted that common law rights aren't supposed to be affected by its decision. And this is on page 590. Parties may contemplate enforcement under state statutory or common law, for example, where judicial review of different scope is arguable. They gave no reason why in the FAA they can't have pendant jurisdiction over common law rights like agreeing to full judicial review. Another problem with the court's reasoning is that it never looks at the purpose of the FAA, which was intended to limit a very specific kind of what you might call judicial review, and that was courts refused to enforce pre-dispute agreements to arbitrate. Turns out in Hall Street, it was a post-dispute agreement, but putting that aside, that's the pre-dispute problem was one where courts interfered with the party's choice and refused to enforce it. So it limited party freedom. The Hall Street problem is that the court refused to enforce what the parties agreed, so it hurt party freedom and it makes arbitration a less useful procedure because the parties themselves can't activate a right to full judicial review. And I'll give you two other short reasons because I don't want to use too much time. One is that to me, it is fundamentally illogical to say parties, everybody, parties, individual, corporate has a right to use our courts, but parties are free to opt out if they agree under certain conditions where we enforce it. But we won't let parties opt out for the trial and still keep judicial review. So they can opt out fully, but they can't do the lesser thing of giving up this publicly funded system just for the initial merits hearing, but still get court review. To me, that is basically illogical and disrespects the party's right to choose how they want their arbitration to proceed. And one last problem, which I also think just shows the court gave a way too short decision and did not think through the problems. If the court were right that grounds outside the FAA cannot be raised in an appeal under the FAA, that would mean that not just the common law ground of manifest disregard, but also the illegality doctrine, which was the root of the public policy violation, the second big common law ground, would not be available. And the Supreme Court, in my view, cannot possibly admit that the illegality type grounds, which is buried in its cases in the middle of the last century, is a fundamental doctrine, is beyond the power of courts in the FAA. So as I said, we propose a short paragraph where Congress could amend the FAA. It might be in Section 10A4, it might be in a new section, to authorize full or partial judicial review where the parties agree. And also, I think Congress should carefully affirm that courts can strike down agreements for illegality or violating public policy so Hall Street doesn't do even more damage. It's thrown the manifest disregard doctrine into total confusion because some jurisdictions say it doesn't exist, some say it do, and then they disagree on how. But the whole opinion is badly reasoned. We think it damages arbitration. End of story.
Thank you, John. I think, Sarah, you're up next to talk about the Part 7 on diversity, inclusion, and opportunity.
Thank you, Jill, and thank you, Rick and Jill, for giving us the opportunity to opine on arbitration. How lucky are we to be living in this time where it is the 100th anniversary of the Federal Arbitration Act? So maybe there's a little more attention to the underlying statute than there has been. And listening to my co-panelists here, I just can't get over how much I think everyone has such great ideas about how to reform the Federal Arbitration Act. And from my perspective, the issue of arbitrator selection is one that the Federal Arbitration Act pays very little attention to. And largely, I think that's because they expected whatever the parties agreed to be followed. And in the case that parties refused to participate in the process, the court could appoint an arbitrator. So there's very little in the FAA about arbitrator selection. But there's obviously been a lot more attention over who is arbitrating these cases, particularly because we require consumers and employees to participate in this process through adhesive agreements. And so more attention, I'd say, in the last 15, 20 years has been paid to who is arbitrating these cases. And the focus of this part is on how to increase diversity among those who might be arbitrating these kinds of cases. And it's important in this context, I think, both Andrea Chandrasekhar's work, empirical work, is excellent in terms of showing just how rare it is for particularly minorities, but also women, to be selected as arbitrators or to even appear on a roster. And you might say, so what? This is party choice. If people want to have older white male arbitrators, there's nothing wrong with that. Why not? Why don't we permit that? Or why should we continue to ignore the possibility that that might have an impact in arbitration more generally? And one of the reasons why I think focusing on diversity in arbitrator selection is important is because of the perceived unfairnesses of arbitration. Whether those perceived unfairnesses are actually real or not, is a subject of debate for sure. But until Ron's suggestion of eliminating these kinds of agreements from the Federal Arbitration Act occurs, at least one way we can address this perceived unfairness is to improve diversity among those who are potentially being selected to arbitrate. Now, of course, be careful what you wish for. Just because you have a female arbitrator or a minority arbitrator doesn't mean they're going to rule in your favor. In fact, Pat Chu did some really interesting research on female arbitrators and sexual harassment disputes, finding that they actually are less favorable to women claiming sexual harassment than male arbitrators. So it may not always be the case that having an arbitrator who looks like you means you're going to get a result that you want, but certainly it creates less of an obstacle to parties, at least to feel like they're represented in some way in the arbitrator roster. And there have been many efforts over many years, still many of these are ongoing, that the various arbitral institutions have engaged in. And I talk a little bit about those in the chapter. There are fellows programs designed to increase diversity among arbitrators. JAMS and CPR and AAA all focus very specifically on improving diversity among their arbitrator corps. And I think AAA has increased the diversity of the rosters that they send to parties from something like 20% about 10 years ago to 28%. CPR encourages their clients, the Fortune 500 companies that use their services, to commit to a diversity pledge where they agree to include qualified diverse neutrals among any list of neutrals they propose to signatories of the pledge. CPR is also committed to following what is called the Ray corollary, where 30% of the arbitrators on any arbitrator roster sent to the parties will be diverse, thinking that at least 30%, 30 to 50% of the arbitrators will be diverse in some way. And the idea is the more you see diverse arbitrators on a roster, the more likely it will be that the parties will be willing to select them. So I think one of the important things, Andrea points out that arbitrators aren't selected, diverse arbitrators aren't selected very much, but why is that the case? And I think a big part of this is nobody wants to recommend an arbitrator they haven't previously used, where they're comfortable with the notion that this is a well-respected arbitrator who they can't be blamed if they ultimately lose in front of them. And so it's a self-perpetuating process where you pick an arbitrator you've picked before, that everybody's picked before. And that's obviously going to favor people who have more experience as arbitrators, which still tends to be older white men who make up the largest proportion of law firm partners and former judges. So it continues to be an issue and probably will be an issue for some time. In my chapter, I talk about possible solutions. One of the things that AAA has done is create a national roster of arbitrators, and they appoint arbitrators to hear consumer arbitration cases. And those cases can be up to quite a bit of money. We could have parties who use AAA services agree to have appointment from a national roster for other types of disputes, particularly employment disputes, where we know the issues of diversity are important to the parties, because oftentimes that's the one way in which they can feel like this person actually reflects my point of view. I've talked about permanent arbitration panels, similar to what unions and employers use. I recognize that's a difficult concept to adopt, where you don't have the same collective action among plaintiffs' employment lawyers that you do with a union. They don't have this, individuals don't have the same power to negotiate it, but you can imagine a scenario in which that might be workable, which I go into in some detail in the article. Probably most, or in the chapter, probably the most, I think possible thing to do is, instead of doing the striking and ranking the way we currently do with arbitrator rosters, is to just have the parties say, this arbitrator is acceptable or this arbitrator is not acceptable. And then let AAA or CPR or JAMS select from those arbitrators who are acceptable. If that worked well, then I think we get more arbitrators with diverse backgrounds having more experience. And again, I think it's largely about making this process a more acceptable process. It'd be nice to think we could dramatically change the Federal Arbitration Act. I'm a little skeptical about that. Even though we've heard some great suggestions here, but in the short term at least, and hopefully in the long term as well, giving more people opportunity to get into this really wonderful field of arbitration, I think would be a benefit to us all.
And thank you so much, Sarah. And I think last but not least, certainly not least of our wonderful chapter authors is Richard Frankel, who's going to talk to us about his chapter about the future.
Hi, and as many have said, thank you so much, Rick and Jill, for all of the work that you've put in to put this book together. Really amazing, and I'm so happy for you that and for all of us that the book is coming out. So when I was 9, I was certain that Walter Mondale was going to be the next president of the United States, and was totally shocked when the election results came out. So I'm not sure I should be talking about anything titled The Future or predicting the future. But I am going to talk about what I think is the book's final chapter in that part, which takes sort of a more summative, kind of reflective approach, looking at the chapters and the book as a whole and thinking about what conclusions one can draw for the future. And so we've all just heard several arbitration scholars and experts and arbitrators propose a variety of changes to the FAA. And these are just a snippet of the 30-odd changes that are proposed throughout the book. Changes to a statute that's very short by comparison to most federal legislation. And these changes range from substantive, carving out adhesion contracts and other kinds of claims from the Act, to procedural, addressing technology and subpoenas, with critiques ranging from what Congress's original intent was and to the law's impact regardless of legislative intent. So this chapter really suggests that rather than slapping on a whole bunch of Band-Aids in an attempt to heal a wounded animal, instead it says the FAA really is wounded beyond repair and should simply be eliminated or repealed. And I admit that it's a great honor to reach the century mark, and may we all be lucky enough to cross that line one day. But as Rick mentioned right at the very beginning, the legal landscape looks very different than it did in 1925 or even in 1953, as John was talking about. And the way that arbitration clauses are now used go far beyond what Congress and the FAA's drafters ever envisioned. And I think if a statute has flaws, right, there are two possible options. There's reform and repeal. And all of the reform options I've heard today and read throughout the book are great. So why not just reform it instead? In my view, at least in this chapter, is that piecemeal approaches lead to piecemeal solutions. And the sheer number of reforms suggested just shows that the law is so permeated with problems that small-scale solutions may not work. And that the sort of logic of carving out particular claims or addressing particular reforms, if we think that one kind of claim should be removed from the FAA, there are probably lots of other types of claims that are similarly situated to those kinds of claims. And the logic for carving out one really applies to many other claims that might not get carved out. So I think that instead, starting from scratch would really allow for a re-envisioning of, in a modern age, in 2025, what the goals of an arbitration statute should be, rather than sort of working on the layer that was created 100 years ago. It could be one that really focuses both on the procedural questions of allowing speedier, streamlined processes that fulfill party intent, but also balancing that with a focus on preserving substantive justice. It could reorient our expectations. We could, center it around our general due process rights, to have notice and an opportunity to be heard, to have a right to a jury trial. These are essential constitutional principles. And I think if we started from scratch, right, we would operate under a system that those who want to take away those constitutional rights or principles should have to justify it. Under our current regime, with the way the Federal Arbitration Act works, those who want to take away a jury trial can easily do so, especially in the adhesive situations that Ronald mentioned. And those who want to preserve court access have to go through all this trouble to try to justify it. And I think that gets things backwards, and repeal would allow us to start over. And also don't think that repeal would leave anything in the lurch. Most states have arbitration statutes. International arbitration can continue to be governed by international conventions. And parties like Apple and Samsung, right, could still, through general contract law, decide to arbitrate the disputes that come before them. So while some statutes, Title VII, the Sherman Act, that were enacted a long time ago, withstand the test of time, other laws, prohibition, excluding women from jury service, don't. And I think this book has shown that the FAA is a statute that has outlived its time and should be eliminated and reconsidered. Thanks.
Wow. So I'll just say, and before Rick can wrap us up, is I was excited for a birthday party, and now Rich has proposed a funeral for the Federal Arbitration Act. So that's really all I have to say. And I just, again, want to thank all of you for joining. Rick, you want to take the last few words?
I don't think I can add anything more than that. When I originally envisioned the book project, I was really hoping that it would be an impetus for significant reform of some sort. I think the politics are a little bit different than I had envisioned. I'm not sure that the politics are necessarily favorable for large scale reform, although there may be opportunities for tweaking bits and pieces here and there. And like you pointed out in your opening, Jill, even if even a few small pieces, a few small recommendations from this book end up getting enacted at some point, I think that the endeavor will have been a good one. And even if not, I think the endeavor was a good one. It brought together some really great people to work on a great project. I think we've delivered a really nice product. We've had an opportunity to work together, and I think that we've all learned a lot about I know I have. I've learned a ton about the statute from the opportunity to have worked with you all. And like I think Steve said early on, the end product is going to be a great research tool for all of us looking into the future. So, thank you, Jill. Thanks to all of you for participating in this. It's been a great experience.
Could I
Jill?
could I ask a question, Rick?
Yes. So if anybody has any questions, either in the audience or on the panel, we have probably no more than 5 minutes. But of course, one thing I forgot to do, sorry, John, is if you want to buy the book, it's on Amazon and it's on Cambridge University Press website. Just search Bales and Gross Federal Arbitration Act, and I'm sure it will come up. Go ahead, John.
My question is that I encourage you two editors to think about whether there is a forum of users, maybe the ABA ADR section, or providers to whom we could provide a list of the reforms. Obviously, some are going to be conflicting. No one's going to agree to all of them, but to try to get some debate and maybe get on some of these, or even one, a critical mass of support where we could get it more publicity. I know there's the June meeting, but beyond that.
Nice idea. Anyone else want to jump in? Right. Not hearing anyone, I think this may be the time to wrap up. Jill, any last words?
No, but I do appreciate Rachel putting in the chat the link to buy the book, because the 2 pennies that we will each earn from each sale is going to take us all the way to Washington, D.C. on our lobby train. So
First class.